Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Hi there, and welcome to the latest edition right here, right now. Ask a Lawyer here on CP24. It's John Scholes, your host, and joining me momentarily, employment lawyer Lior Samfiru from EmploymentLawyer.ca. The guarantee we offer over the next 30 minutes is you're going to learn something, and it's about employment rights, so it's always important to all of us. And throughout the show, we always give you the contact information, right? So I'll do that first. To call Lior and his team anytime on your own time, 1-888-861-4555, ask@employmentlawyer.ca. We always have a main topic too, and this week it will be everything you need to know about the Ministry of Labor. A huge topic and super important one. That's in just a bit. That will get to some phone calls from one of our radio shows, which, by the way, you can tune into and participate in every Sunday right here in the GTA, News Talk 1010 at 1 p.m. Hope to join on one of those shows as well. Maybe your phone call will get played back here on this show. But we always start off, Lior, with the week that was, something that's been happening on your end, pal. What do you got this week?
Hey, John, great to be here. As usual, great to be talking about employment law. Thank God we're talking about that. That's the one thing I actually know something about. So really want to have this opportunity, like I do every week, to educate, to inform, to make sure that you know what to do if you're facing a workplace problems. Things are not always going to be great at work. Sometimes your boss may do something or says something. Maybe you get a different boss now that doesn't treat you well, and you have an ultimatum. You want to know what to do, what your rights are, or whether what the company is doing is legal. On this show, we tell you these things. We tell you what you need to know. We help educate you, and we arm you with that knowledge. You're stronger, you're better if you have that knowledge. And on this show, you'll learn what to do if you've been dismissed, if you've been mistreated, if your job has changed, your compensation has changed, you have an injury, you name it, you'll learn it on this show. And of course, beyond the show, if you want to reach out in my team, we have a huge team ready to help you. You can reach out through the phone number and the email address you'll see on the screen, and we'll give you throughout the show. But now that we know what we want to do, let me start by telling you about a situation that came across my desk very recently. I spoke with a gentleman who had to go off work because of an injury. He had an injury to his knee, and it meant he couldn't work. He did the right thing. He got his doctor's note, and of course, he also applied for short-term disability. We had that through his workplace benefits plan. The insurance company was giving him a hard time. Initially, he was denying it. He was dealing with trying to convince them. They felt he wasn't injured enough. Well, his employer, in the meantime, hears that. His employer says, "We understand you haven't qualified for disability benefits. That means you're able to work. Therefore, we expect you to be back to work by the end of the week, or else we'll consider you to have abandoned your job." Now, keep in mind, he is injured. He did provide them with the doctor's note. He's frankly freaking out, right? He doesn't want to lose his job. He needs this job to support his family. So he calls me and he wants to understand his rights. Well, his employer cannot rely on what the insurance company is saying. The only thing his employer should pay attention to is his doctor's note. Because he had a doctor's note saying he can't work, that's it. His employer cannot do anything about it. His employer cannot disbelieve it, threaten him, say that this is a lie. Nonsense. If he has a doctor's note saying he can't work, he can be off as long as he needs to. There's no time limit on that. So I'm going to get involved right now. I'm going to get his employer off his back. He's not going to lose his job. And I'm also going to help him deal with his insurance company that's giving him a hard time, not wanting to pay him short-term disability benefits. If any of this sounds familiar to you, if your employer is giving you a hard time about being injured or unable to work, if your disability insurer is giving you a hard time about getting benefits, call me. Let's take care of those problems.
Well, as we mentioned off the top, Lior, the radio shows across the country, you want to find a market near you. It's simple. Go to EmploymentLawyer.ca, the media section, including right here in the GTA, News Talk 1010 is where you'll find us Sundays at 1. And the phone number anytime, 1-888-861-4555. Ask@EmploymentLawyer.ca to reach out in any other regard. Phone call number 1, Leo, let's get to it right now and talk about it. Here we go.
I was managing 2 stores, 7.5, 8 years, and the owner decided just reduce me to 1 store, and he reduced my pay as well, right? He's paying me for 1 store. He didn't give me enough notice for that, so you're going to run only 1 store.
Well, the big issue here is the reduction in pay. If he was asked to do less work and getting paid the same, well, okay, I guess that's fine. But an employer cannot reduce your pay in that way. So if the company decides for its own reasons to give him less work, but also now pay him less because of that, can't do that. That's what we call a constructive dismissal. Your employer cannot make significant changes to the terms of your employment. And in this case, that significant change is the reduction in pay. It doesn't have to be, it could be other changes. All of those could be constructive dismissal. But John, in this case, we're talking constructive dismissal. He can consider this reduction as being a termination and require his employer to pay him his full severance. Question, of course, then becomes, well, how much severance does he get? You know what I'm about to do. I'm going to use our great tool, the severance calculator. You can find that at EmploymentLawyer.ca. Let's plug the information in and see how much compensation he's owed as a result of the constructive dismissal. So we know he's a manager, he's managing store, been there for about 8 years. Company reduced his pay. It's a constructive dismissal. You can see right there in yellow that he's owed as much as 14 months severance. 14 months severance. Even though the company didn't let him go, just by virtue of reducing his pay, by virtue of constructively dismissing him. Same with you at home. If you lost your job or if it's a constructive dismissal, remember your rights and always check out EmploymentLawyer.ca.
All right, Lior, good stuff. Let's get into a short break. Upon our return, it is everything you need to know about the Ministry of Labor. We'll get into that, so stick around for it. In the meantime, that number again, 1-888-861-4555, and email Lior and his fantastic team, ask@EmploymentLawyer.ca. This is Ask a Lawyer. It's right here on CP24. Hang on.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back. Thanks so much for sticking through the break. John Scholes here, Lior Samfiru, our employment lawyer from EmploymentLawyer.ca here on Ask a Lawyer every week. You can always reach out to Lior. As he said, he's got a great team, a big team behind him. 1-888-861-4555, ask@EmploymentLawyer.ca if you prefer the email route. Okay, this topic is good this week because it pretty much, it's where everyone's going to go if and when the time comes, Lior, they lose their job. We're going to be talking about everything you need to know about the Ministry of Labor. That said, is the Ministry of Labor misleading people when it comes to their employment rights? What do you think?
Well, we have to understand what the Ministry of Labor is and what its function is, at least as it relates to individuals. So the Ministry of Labor essentially has to administer the Employment Standards Act. The Employment Standards Act is legislation that outlines certain minimums that people have. Minimum wage, minimum amount of vacation you get, etc. That's what the Ministry of Labor does. The problem is that in certain situations, your rights don't come from the Employment Standards Act. That's especially true when it comes to termination of employment. Your rights when it comes to termination, most of them don't come from statute, don't come from the Employment Standards Act. They come from our common law. And the Ministry of Labor cannot advise on that. So I'm not going to say that the Ministry of Labor misleads you, but when it comes to in termination of employment, the Ministry of Labor can only advise you with respect to a tiny fraction of your rights. And if you don't know that that's what the Ministry of Labor is doing, you're going to walk away thinking that you have the answer when you actually don't know what you're owed and you got information that's incomplete.
So based on that incomplete information, people are generally getting the wrong advice from the Ministry of Labor. Give me an example of what that would be.
Well, let me use a situation. You don't believe me, you can try it for yourself at home. So Ministry of Labor has a 1-800 number. You can find it on their website. Call them with this scenario. Tell them, I just lost my job because of a restructuring. I've been there for 3 years. What am I owed? They're going to tell you in 5 seconds that you're owed 3 weeks, okay? The problem is that's wrong. You could easily be owed 6 months, 8 months, even 12 months of severance, not 3 weeks. Your 3 weeks may be your minimum entitlements. Your full entitlements can be 10 times that or more than that. So that's what happens. And every single day, people call the Ministry of Labor for advice when they lose their job, not realizing that the information that they're given is actually not correct. It is not proper and it's not full. That's why we do the show, so that you understand not to make that mistake and not to be misled by incomplete information.
Where can they go in that case? I mean, 3 weeks to 6 months is a huge delta. Where do they want to go for accurate advice? We all want it, right?
You want it, you have to have it. Well, for that, you have to get legal advice. We created the Severance calculator. That's one way to go. EmploymentLawyer.ca is where you're going to find that tool. You can call me, you can email me. You don't like me, speak to another employment lawyer, that's fine. But when it comes to losing your job, what you cannot do ever is go to the Ministry of Labor. Not for that. You have to speak with the lawyer, use the severance calculator, do the right thing to get the complete information.
Again, we're talking about everything you need to know about the Ministry of Labor and dealing with them or not dealing with them in whatever case. So if someone gets bad advice from the ministry, where do they go? Where do they turn?
Well, they call me, EmploymentLawyer.ca, the place to go, John. Takes seconds and you get the right information.
So in what cases should people contact the Ministry of Labor? Is there a good time to contact them? We know it's not for severance. Don't go there for sure, right?
So any situation that has to do with losing your job, whether it's a termination of employment, constructive dismissal, you can't go there. But if you have an issue that you're not getting paid your overtime, absolutely, you can and you should go to the Ministry of Labor. If your vacation pay is not being paid properly, your statutory holiday pay is not being paid properly, absolutely. Your employer missed your last paycheck, they didn't pay that, absolutely, go to the Ministry of Labor. But if it comes to your continued employment, losing your job, constructive dismissal, certainly if it has anything to do with human rights or discrimination, for that you cannot go to the Ministry of Labor. For that you have to seek legal advice. Give me a call, send me an email, let's do it right.
And as Lior mentioned, EmploymentLawyer.ca, free anonymous website. You can use out a lot of this information. The correct information will be on that website, free for you to use anytime. And as we did in the first segment of the show, we'd like to get to some phone calls from our long-running radio shows. Sundays, 1 p.m. News Talk 1010. You'll catch Lior and I doing our thing. A chance for you for the entire hour to call into the show and ask your questions. Lior, phone call number 2 for us is coming right now.
Well, my sister has been working for about 12 years for a dental agency. And about 5-6 years ago, her employer had provided one of those agreements that you were just talking about and said, nobody gets an increase unless they sign these agreements. Now, she's refused to sign the agreement every year, and she hasn't had an increase in 6 years. And I wonder if there's any recourse for that.
Yeah, interesting question, but here's the thing. An employer is not legally required to provide a pay increase. So an employer can say, I'm only going to give a pay increase to those people that sign a new employment agreement. That's not fair, it's not nice, but it's not illegal. But here's the key part. She should be happy that she did not sign that employment agreement, because I can assure you that by signing that employment agreement, she'd be losing a lot more than this pay raise that the employer was dangling as an incentive. She could be walking away from tens and tens of thousands of dollars in future severance. She could be giving the company the right to lay her off temporarily, to change her job, change her pay. Anytime your employer introduces a new employment agreement to you, even though you're an existing employee, be worried. Don't just sign it, no matter what, certainly not without speaking to me first.
Great phone call. Got one more to go, Lior. We're going to do it on the other side of the break, so stick around for that. I know you want to dive right into that one. In the meantime, the phone numbers we get into that break again, 1-888-861-4555. Email is ask@employmentlawyer.ca, ask@employmentlawyer.ca. And we'll continue with more Ask a Lawyer here on CP24.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. Again, you can catch us on the radio anytime as well. Sundays, 1 p.m. News Talk 1010. Lior and I doing our thing. And to reach out to Lior, you can anytime or a member of his team, 1-888-861-4555. Email ask@employmentlawyer.ca. I mentioned the third phone call of the show from one of our radio shows, Lior. We're going to play it back. We're going to talk about it. And we'll do it right now. Hang on.
I just got laid off today, and I'd like to know how much severance I'm owed. 17 years. Filing clerk, 47.
What have they offered you?
6 weeks.
They give you advance notice of your termination?
Nope, but I just walked into the office today, and they laid me off.
Wow, what a terrible, terrible offer, and what a terrible employer, frankly, that they think they can get away with paying 6 weeks to a 17-year employee. Nonsense. That's illegal. That's a wrongful dismissal. So obviously this person is owed more, and here's how she finds out. Here's how you can find out how much you're owed, whether the company's offer is good. I've said it before. I'll mention it again. EmploymentLawyer.ca. That's our severance calculator tool. I'm going to use it right now to plug in this information and to see what the real answer is. So this person's been there for 17 years as a filing clerk. Company, for its own reasons, thinks it can only offer 6 weeks. Nonsense. You see there, it's actually 16 months. 16 months is what she's owed, probably even more than that. So that is how easy it is to use the severance calculator. This is a terrible offer, unfortunately. I see these situations all the time. Don't let it happen to you. EmploymentLawyer.ca.
And the email address, ask@EmploymentLawyer.ca, is where we're going to go now. Lior got this email recently. Says, my girlfriend was a supervisor in the hospitality industry for 4 years. The company just sold, and the new owners said they didn't have work for her, and they gave her a week's pay. 1 week. Is severance less when a new business is involved?
Great question, but the answer is no, it's not less. If you continue working, your seniority doesn't just start at zero. It doesn't get extinguished. Whether you lose your job because of a sale of a business or you start working with a buyer and then you are let go, your seniority is your seniority. Unless you sign an agreement that gives away your rights to your past seniority or that limits your service, then no, you're absolutely owed your full severance. So in this case, she's owed much more than a week's pay. Again, that's a wrongful dismissal. The answer, of course, is give me a call. Let's get it resolved.
All right, good stuff, Lior. We'll take one more short break. We got another question for you on the other side. Here is a number to reach Lior, as he just mentioned. Anytime, feel free to do so. 1-888-861-4555. Email ask@employmentlawyer.ca. This is Ask a Lawyer. It's here on CP24. Hang on.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Okay, welcome back to Ask a Lawyer here on CP24. Let's keep it going. John Scholes, lawyer every week, of course. Lior Samfiru from EmploymentLawyer.ca. To reach out by phone, 1-888-861-4555 and ask@EmploymentLawyer.ca. Lior and the crew do a ton of live streaming as well on YouTube and Facebook. You want details and how to join in, simply go to stlawyers.ca. Lior, here's the question from the live stream for this week. Says, guys, I was just given a bad performance review by a new manager. The company handbook says I should get additional training after a bad review, but instead, I hear I may be fired. Would this be a wrongful dismissal?
Well, here's the thing, John. If the company wants to let this person go for cause, to say, oh, you're such a bad employee, we can let you go for cause, we're not going to have to pay you severance, well, good luck to them. They're not going to be able to do that because they haven't met their own obligations to try to improve performance, to provide training, to provide help and support so that this person can do their job the right way. So it's not going to be possible for them to even contemplate a termination for cause. On the other hand, if the company wants to terminate on a without cause basis and pay full severance, they can. Remember the general rule that a company can let you go pretty much for any time as long as severance is paid. But the fact that you got a bad performance review in and of itself does not mean you can be let go for cause or you got a warning. No, it's extremely difficult to deprive you of severance. It's extremely difficult to terminate your employment for cause. Just because you did something wrong or a few things wrong doesn't mean that the company can do that. In most cases, that's a wrongful dismissal. So if the company is trying to deprive you of severance, saying you're such a bad employee and they don't have to pay it, nonsense. Give me a call. Let's make sure you get everything you're owed.
With that bad review now on your record, would they use that to try to lessen the amount of severance they're going to give you? Does it change the calculation at all or no?
So it's easy to think, well, okay, they have to pay me severance, but maybe they have to pay me less because I made a mistake. No, it doesn't work that way. Either you get your full severance, or if you did something horrible, you don't get any severance. But there's no such thing as reducing the amount of severance. The company doesn't get a discount. The company doesn't get to say, well, we'll have to pay you less. So unless what you did is deserving of the worst punishment, you can get your full severance, and that could be as much as 24 months pay. Again, even if you may have made a mistake. So a mistake does not equal being deprived of severance, not even close.
You know, it's interesting, 2 words in our employee handbook. We never hear that mentioned. How important is that document for the employer and the employee, I guess, right?
Well, certainly for the employee, always read the document. You want to understand what your obligations are, what your employer's obligations are, and what you're agreeing to. An employer should have a good, robust, and updated handbook. But for an employer, having a handbook sitting in a desk somewhere is useless. You need to make sure that your employees get a copy of it, that they're explained what's in it, they're provided the opportunity to read and ask questions, and only then can an employer rely on it. Too many employers stick it in a drawer and forget about it. That's not how to do things.
Do you have them sign off on it, or just here, read this on your own time, or make sure they've gone through it, sign off on it?
Well, you always want to avoid a situation where there's a question, did the employee get the handbook, did they not get the handbook? So always a good idea to get them to sign that they received it, that they've read it, and that they've understood it. Good policy, good practice for employers to have.
One of these days I'm going to stump you with a question, but tonight is not the night, my friend. So we'll try it next week. If you want to reach out to Lior anytime now that we're done, again, PocketEmploymentLawyer.ca. Wonderful website to start that little adventure. You'll have access to the severance calculator too. And phone numbers 1-888-861-4555. Email is ask@employmentlawyer.ca or just employmentlawyer.ca for the firm. And a reminder once again, please join us. Make those phone calls. Join us for the hour, Sundays, 1 p.m. on News Talk 1010 for our radio show every week as well. Thank you so much for joining us. We'll catch you next time right here on Ask a Lawyer. This is CP24.